Okay, good morning, good afternoon, or good evening from wherever you are joining us. I, on behalf of the Cambridge International Law Conference Organization Committee, welcome you to panel 7 of the 11th Annual Cambridge International Law Conference. The topic for today, apologies, the topic for today is strengthening roles of established and emerging actors in global governance. I would like to introduce our chair for the panel today, Dr. Nafay Choudhury, who is a junior research fellow at St. Catherine's College at the University of Cambridge. His work sits at the intersection of socio-legal studies, legal pluralism, economic development, and the rule of law. His current research looks at the role of market associations in providing normative order in fragile settings. Dr. Choudhury completed his Ph.D. at King's College London, where he undertook an ethnographic study of Afghanistan's money exchangers to understand the interaction of state and non-state legal systems in the production of legal order. He has been a research fellow for the Institute for Global Law and Policy at Harvard Law School since 2019 and is a senior research fellow at the Afghan Institute for Strategic Studies. He was previously a postdoctoral fellow at Stanford Law School for the Afghanistan Legal Education Project, concurrently serving as assistant professor of law at the American University of Afghanistan, where he helped launch the country's first English medium law program. He has received various grants to explore issues of social and legal ordering, economic regulation, and social networks. He led a project supported by the government of the Netherlands on the distributional effects of property reforms in Kabul's peri-urban spaces, and he holds a JD/BCL from McGill University, an MA in economics from Queen's University in Canada, and a BA in economics from McGill. I would now like to hand it over to Dr. Nafay Choudhury to begin the panel. Over to you.
Thanks so much for the introduction, Ross, and thanks everyone for participating in this, incredibly enriching and enlightening panel. As you know, I'm going to make this introduction very short so we can focus on the meat of the substance, which is the presentations that we have. And as you know, the panel is entitled Strengthening Roles of Established and Emerging Actors. And I think this is an incredibly enriching panel if you've gone through the presentations and the papers that have been provided for this panel, because it shows how we're looking at international law through, to some extent, somewhat unconventional lenses, new ways of seeing kind of the edges or the boundaries or the frontiers of international law. I mean, when I thought about this panel, I thought about the way you sometimes shine light into a prism that you do when you're in high school or in junior high, and then that prism breaks up that light into its component parts, and you see like the rainbow. And that's what this panel is doing. It's shining international law through a prism. And then we're seeing that, wait, it's not as coherent in the way that we think. There's so much variability in the way international law exists and the way actors are able to assert themselves. And so this panel is going to talk on topics such as, covering cities, the UN General Assembly, Global Assembly, academic law making, REDD+, and it's going to bring up issues such as state versus non-state actors, ambiguity versus certainty in the way we understand law and lawmaking. And I think there's a lot of overlap between the various presentations, because all of the presentations and all of the speakers and writers and scholars here are really talking about law in terms of international law, in terms of, kind of frontier discussions where we can really push the boundary. And so I'm not going to go any further because I'm going to go straight into the presentations now, and we'll begin with Rebecca Barber. And before before I give the floor to Rebecca, I guess in terms of the timing, each of you have 15 minutes to speak. Some of you might be looking at your screens, so you might not see me, but I still will put up the 2-minute mark, and as well as the wrap it up mark. But I'll also, for the wrap it up, I'll also type it. I'll probably try to privately message you as well, wrap it up. That way, even if you're not looking at me, you'll know that you're reaching the 15-minute mark. And also, I'll just remind you that since we've had your papers, a lot of the rich discussion comes up in the Q&A. So that's why you really don't feel the need to prolong it. Like there's a lot of richness that we want to hear from the participants as well as the discussion that'll follow. So without further ado, I'll give the floor to Barber, and I'll just do a very quick introduction of each speaker before, and I'll leave the Q&A until the end. That way there isn't an imbalance between the different speakers and the amount of questions being asked. So Ms. Barber is a research fellow with the Asia Pacific Center for the Responsibility to Protect and a PhD candidate with the University of Queensland's Law School. Her research focuses on the competence of the General Assembly in relation to atrocity crimes. So I'll give the floor to you, Rebecca.
Thanks so much, Dr. Choudhury. I will just share my screen. Okay, thanks so much to the conference organisers and Dr. Choudhury for that introduction. It's a pleasure to be here speaking at this conference and on this panel. My presentation is on the role of the General Assembly in determining the legitimacy of governments. My presentation is in 3 parts. The first part briefly reviews the issue of the political recognition of governments and seeks to clearly delineate the legal implications of that recognition, particularly for purposes of international law. The second part looks at the General Assembly's credentials process and the relationship between that process and the political issue of the recognition of governments. And the third part looks at the role of the General Assembly in determining the legitimacy of governments. Most governments today have policies of not formally recognising other governments, at least in the sense of granting certificates of recognition or making explicit public statements regarding the recognition of a government. However, governments do still inevitably have to decide who they will treat as the government of a state. And moreover, in some cases, they do feel compelled to publicly communicate those decisions for various reasons. Put up here a few examples on the slide. In 2016, for example, in relation to Libya, France, Germany, Italy, the UK and the EU made an announcement that they would work closely with the government of national accord as the only legitimate government in Libya. In relation to Venezuela in 2019, the UK made an announcement that it recognised Juan Guaido as the constitutional interim president of Venezuela. And in relation to Afghanistan last year, the Canadian Prime Minister announced that the Canadian government would not recognise the Taliban as the legitimate government of Afghanistan. And there are numerous other statements that can be cited along similar lines to these. International law and practice is seemingly very clear that governments have absolute discretion in deciding whether or not to recognise other governments, and that such decisions are not open to interrogation by domestic courts. This was recently affirmed very clearly by the UK Supreme Court in relation to a dispute over which authority had access to Venezuelan assets that were held in UK banks. In that case, Lord Justice Lloyd Jones said that there is nothing to prevent the government from tendering to the courts an unequivocal certificate of recognition or non-recognition of the existence of a foreign government, and that where the government does issue a formal statement of recognition or non-recognition, that will be taken by the court as conclusive. I personally think that this idea that governments have absolute discretion in deciding whether or not to recognise another government, and that such decisions cannot be interrogated by the courts, is problematic because it suggests that the government's power to recognise or not recognise another government is unconstrained by law. So it means, for example, that at the domestic level, governments have unfettered discretion to determine matters such as which entities may access state assets held in the banks within the jurisdiction of the recognising government, as in the Venezuelan case, and that such decisions cannot be reviewed by the courts. At the domestic level, it may be that this legal status quo is justified by the prerogative of the executive in matters of foreign affairs, but it becomes more problematic if the competence of governments to determine the rights and responsibilities of other governments is extended to the international plane. So extrapolating from the jurisprudence of the courts on this issue, including in the Venezuelan case, one could be mistaken for thinking that not only can governments unilaterally determine which entities can access assets held in banks with their own jurisdiction and other matters on the domestic plane, but also issues such as which entities may legally request and receive foreign military assistance, and which entities or individuals may be entitled to personal and functional immunities. But obviously this cannot be the case because these are matters that are regulated not by domestic but by international law. So I think what's important to note is that the discretion of governments to recognise or not recognise other governments has been affirmed as operating at the domestic level for domestic purposes. It can't mean that governments are competent to unilaterally determine the rights and responsibilities of other governments for purposes of international law. I'm going to briefly illustrate this point with reference to situations in which, in cases of disputed governance, one or two competing authorities claiming to be a government has requested and received foreign military assistance. In situations in Haiti in 1991, Sierra Leone in 1997, Mali in 2012, and Yemen in 2015, military assistance was provided at the request of governments that did not have territorial control. I should add that it's well established in international law that international law allows military intervention at the request of the government, but not at the request of the opposition. Most of the interventions in these cases were not authorised by the Security Council, but nevertheless, they were generally regarded by the international community at large as legal. One of the things that all of these cases had in common was that the requesting governments were internationally recognised as legitimate. Conversely, when Russia intervened militarily in Ukraine in 2014, the intervention was provided ostensibly at the request of the ousted Ukrainian president. However, as we all know, it was almost unanimously regarded by the international community as illegal. So in other words, Russia was clearly not at liberty in that case to decide who was a legitimate government and then to intervene militarily at his request. So I think what these cases suggest is that if we're to understand that recognition is a unilateral decision that states may make according to their own criteria, then it must also be understood that such decisions do not conclusively determine a government's rights and responsibilities in international law. In order to determine the status of a government for purposes of international law, it seems that what is required is some sort of international recognition. The problem, though, is that there is no established process in international law or practice for collectively determining the status of governments. What we do have, though, is a process by which the General Assembly determines the eligibility of delegates to represent their states at the General Assembly's own session. And this is known as the credentials process. The rules regulating the credentials process are procedural in nature. Rule 27 of the General Assembly's Rules of Procedure says that the credentials of representatives shall be submitted to the UN Secretary General at least 1 week before the opening of the session, and that they shall be issued either by the head of the state or government or by the Minister for Foreign Affairs. Credentials are considered by the General Assembly's Credentials Committee, which makes a recommendation to the General Assembly plenary. And the General Assembly plenary usually accepts the committee's recommendations without any discussion or debate. While it is primarily a procedural process, in cases where two or more authorities both submit credentials at the same time, claiming to represent the same state, the General Assembly does not have a choice but to involve itself in substantive issues of government legitimacy. In such cases, the only thing that the General Assembly has formally to go on by way of guidance is General Assembly Resolution 3965 from 1950, which says that whenever more than one authority claims to be the government entitled to represent a member state in the UN, the question should be considered in the light of the purposes and principles of the Charter and the circumstances of each case. In practice, since the 1990s, in contested cases, the General Assembly has almost always favoured the democratically elected government, or at least an internationally recognised one, irrespective of the question of which authority exercises effective territorial control. We saw this most recently in relation to Afghanistan and Myanmar last year, with the General Assembly deciding to defer its decision on the representation of those countries in the General Assembly, with the result that the previously credentialed incumbents representing the democratically elected governments in both of those countries remained in place. The credentials process has traditionally been understood as procedural in nature. In 1970, the UN Legal Council issued a memorandum which described the credentials process as a procedural matter limited to assessing compliance with the General Assembly's procedural rules, not involving questions of recognition or substantive issues concerning the status of governments. But the problem with insisting that the credentials process is a procedural process, being only about the representation of states at the UN, is that the international system has no other process for collectively establishing the status of governments. And so long as there is no other process, there is a tendency for the credentials process at the General Assembly to be looked upon to fill the gap. On the other hand, while the credentials process is sometimes looked upon for guidance on matters of government legitimacy, the General Assembly's decisions on credentials can also still leave room for confusion, particularly in cases such as Afghanistan and Myanmar, when all the General Assembly does is defer its decision on representation, which by default allows the previously credentialed representative to remain in place. And we're seeing this confusion playing out now in relation to Myanmar. Myanmar is currently represented at the General Assembly by the National Unity Government and at the International Court of Justice by the military junta. And at the Human Rights Council, it now looks like Myanmar will be excluded altogether because no decision can be reached in that forum regarding Myanmar's representation. The General Assembly is competent to provide guidance to the international community at large on the matter of who should be regarded as the government of a state in contested cases. And it has done so on numerous occasions in the past. Put up here a few examples on the slide. In the 1970s and 1980s, in relation to apartheid South Africa, the General Assembly passed a resolution proclaiming that the racist regime of South Africa is illegitimate. In the 1970s, in relation to Namibia, the General Assembly passed a resolution recognising the National Liberation Movement of Namibia as the authentic representative of the Namibian people and calling upon states not to recognise any authority which the illegal occupation regime may install. Following the military coup in Haiti in 1991, the General Assembly passed a resolution affirming as unacceptable any entity resulting from the coup. And similarly, following the coup in Honduras in 2009, the General Assembly passed a resolution calling upon states to recognise no government other than that of the constitutional president. General Assembly resolutions on the legitimacy of governments, such as these, have in practice served as a guide for actors both inside and outside the UN system. Following the resolution on Haiti, for example, the Security Council adopted a resolution which referenced the General Assembly's resolutions and imposed sanctions on the junta, and later it authorized a multinational force to facilitate the restoration of the legitimate authorities of the government of Haiti. Following the General Assembly's resolution on Honduras, the UN Office of Legal Affairs advised that the UN Secretariat should act consistently with the resolution, meaning that only representatives of the previous government should be allowed to participate in the work of the General Assembly and its subsidiary bodies. And subsequently, the Organization of American States decided to suspend Honduras from the OAS. A determination by the General Assembly regarding the legitimacy of a government doesn't affect the right of states to engage bilaterally with the government in question. However, governments will presumably be less likely to engage bilaterally with a government that has been described in a General Assembly resolution as illegitimate. More importantly, a General Assembly resolution of this nature serves as an authoritative point of reference on the question of which entity should be regarded as the government of a state for purposes of international law, and also for purposes of assessing who should represent the state in question in international forums. So to finish with a current example in relation to Myanmar, the General Assembly could, for example, pass a resolution demanding the restoration of the democratically elected government, the National Unity Government, and calling upon states and international bodies to refrain from according any recognition to the military junta. Thanks so much. I'll leave it there. And I really look forward to any questions and the discussion.
Thanks so much, Rebecca. That was perfectly timed and extremely clear. And I'm going to keep the questions until the end where all of us can have a discussion on it. I probably should have mentioned earlier that if people in the audience or your co-colleagues also have questions, please do add them into the question answer box and we'll collect questions so that we can immediately jump into an engaging discussion afterwards. Perfect. So we'll go on to the next speaker, Dr. Leslie Ann Duvic-Paoli. And Dr. Duvic-Paoli is a senior lecturer in environmental law at the Dixon Poon School of Law, which I'm very familiar with, where I did my PhD, and the deputy director of its Climate Law and Governance Center. Her scholarship covers the ambiguous role played by environmental principles and global legal implications of the clean energy transition to the role of citizens' assemblies in the making of climate law and policy. So I'll give the floor to you, Leslie Ann, for 15 minutes.
Thank you so much. It's really a pleasure to be here with you all today. My presentation is going to be about an unconventional mechanism of global climate governance, and that's the Global Citizens Assembly on the climate emergency. This year, in 2022, we are actually celebrating a milestone for international environmental law, as we are commemorating the 50 years of the Stockholm Summit on the Human Environment and also the 30 years of the UN Framework Convention on Climate Change. Yet, at the same time, this celebration is a bit bittersweet because we are seeing that international environmental law has failed to provide adequate responses to the ecological and climate crisis. In particular, in the field of climate change, conferences of the parties, COPs, have been really widely criticized for being unable to respond to the scale and urgency of a climate crisis. And so what we have seen last year is the creation of a new institution of global governance, this Global Citizens Assembly on the Climate Emergency, that was launched in October 2021 to respond to these criticisms. So what are climate citizens assemblies? They are a sort of mini public that bring together randomly selected citizens that are representative of a wider public. And they are asked to make policy recommendations on how governments should respond to the climate emergency. They are becoming now an increasingly common feature of domestic climate governance. And we see that several citizens' assembly have been held at the national level in Ireland, the United Kingdom, France, Germany, Austria, etc. And so the Global Assembly aims to replicate and extend this model to the global scale. It's organized by civil society, and the question that is asked of citizens is how humanity can address the climate and ecological crisis in a fair and effective way. The organizers have described the Global Assembly as, I quote, a new operating system for global governance that will enable everyday citizens to have a seat at the global governance table. And it aims to become a permanent institution of global climate governance by 2030. So my presentation today offers some initial reflections on the first year of this quite unique body, and I'm trying to test the rationale that underpins its creation, and that a forum for citizens' deliberation can have positive implications for the making of international climate law. So to do so, first I'll start by giving a few more a bit more information on the Global Assembly, and then I will be looking at the rationale that underpins the creation of the Assembly, and then I will be discussing the first outcome of a Global Assembly that was adopted in December 2021, and that is entitled People's Declaration for the Sustainable Future of Planet Earth. So as I've said, the Global Assembly is a civil society initiative that brought together people working in social movements, science, educators, etc. And the reasons they put forward for holding this assembly is that they hope that it will create a political mandate for change by enabling large numbers of people to design solutions, and that it will improve global decision-making by offering a platform to everyone on the planet to be heard at the global level. The Global Assembly is actually made of two initiatives that run in parallel. The first one is the Core Assembly that brings together 100 people that have been selected by sortition to represent a snapshot of the world's population. And the second initiative are community assemblies that are held locally by communities who are interested in discussing this question of climate change at a more local level. In this presentation, I'm mostly focusing on the Core Assembly because the objective of the Core Assembly is to feed into the Conference of the Parties and the global lawmaking process. So the Core Assembly selected people from 100 different points around the world based on 5 different criteria: geography, age, gender, socioeconomic background, and opinions about climate change. So as a result, we have 60 people who come from Asia, 17 from Africa, half of the members are women, 70 members earn less than $10 a day. They speak 37 languages and 9 cannot read or write. It's very challenging, of course, to organize an assembly like this one because there's very limited experience, and it's creating significant practical questions around how to accommodate very different levels of technological access because everything is organized online, how to accommodate time differences, and I'm sure Rebecca could talk about that, and also how to address the question of language diversity. So the Core Assembly ran either side of COP26 between October and December 2021, and the members met for around 70 hours of learning and deliberation. So they heard from climate scientists and social scientists as well about the climate crisis, and they learned, they were given knowledge about the climate crisis, and then they were asked to deliberate in small groups of 5, and eventually they voted on certain proposals that eventually led to the adoption of a People's Declaration. So my interest for this new mechanism of global governance is really, what does it tell us about international law and international lawmaking? So the first thing that we learn is basically that it shows that there's an acknowledgement that global governance has so far failed to produce adequate international law. The argument that the UNFCCC is a convoluted process that is not fit for purpose is not necessarily new, but we've seen in recent years really a widening gap between, on the one hand, diplomats that are arguing in closed rooms over what are considered to be technicalities, and then on the other hand, citizens, and in particular the youth, taking to the streets to ask for more ambitious action. So we've seen that although the Paris Agreement was designed around what is now well accepted as a bottom-up approach, the mechanisms for its implementation, and in particular the Conference of the Parties, have not been redesigned and are now being criticized for failing to adequately respond to the scale of the problem. And what we can appreciate is that participation in this global climate governance system has really expanded in recent years, in particular with increased engagement with non-party stakeholders since the Lima Paris Action Plan. But at the same time, this proliferation of new actors has not necessarily further democratized global governance. So what we see is that non-state actors are still conceived only as observers of multilateral negotiation processes, and that even when we have some involvement with civil society tends to represent very narrow and specific interest of particular constituencies, and they don't necessarily represent a very diverse set of views. So the Global Assembly aims to actually respond to these criticisms, and it's built on the idea that deliberation has some value and would be able to help adopt better types of laws. The idea is that it enables collective decisions and judgment that will be informed by relevant reasons and claims, that it will promote respect among citizens, and that it will also facilitate the inclusion of new or different voices that are not necessarily heard at the COPs. So while international climate lawmaking is very much focused on deal making, where you have diplomats that are trying to make sure that their preferences are reflected in the final outcome, which means that what we see are ambiguous texts that somehow represent different interests, but that don't necessarily represent a common position. The idea is that if we ask citizens to deliberate, they will be able to listen to each other and come up with a common position that will adequately respond to the climate crisis. At the same time, of course, what is important is to make sure that what is happening at the Global Assembly then has an impact on international lawmaking. And so it's important to have an explicit pathway to impact. And here we see really an ambiguous position from the Global Assembly. On the one hand, it presents its objective as being to make recommendations to the COP, and get an official response from the COP. And at the same time, sometimes it's also saying that what is important is not nation buy-in, but it's the power of the citizens to become aware of the problems and to be able to come up solutions for their own communities. And so we've seen this ambiguity playing out at COP26, where the organizers tried to involve the leaders of COP26, the UN Secretary General, Alok Sharma, who was head of the COP, that were all supported the initiative, but actually there was no dialogue between what was happening at the COP and really what the citizens were doing. So it will be important in the future to think about how to clarify this pathway to impact. But if we look, and that's my final part, if we look at the outcome of a global assembly and that is called the People's Declaration, I think it is also interesting to look at what happens when citizens try to come up with a declaration. And we're very familiar with declarations in international environmental law, such as the Stockholm or Rio declarations. And it's interesting to look at what is the difference between state-driven declarations and citizens-driven declarations. So the declaration is made of a preamble and 7 statements that look at the role of the Paris Agreement, principles of equity and common but differentiated responsibilities, participatory involvement, the right to a healthy environment, the rights of nature as well are mentioned, and questions around educating on climate change and on a fair energy transition. So what is interesting about this declaration is that it tells us how citizens view international law. And it's very interesting that although the Global Assembly itself has been designed as a response to what was seen as inadequate international law, the declaration itself actually is not asking for a completely redesign of the international legal system. It's a declaration that is very much grounded in international law, and legal references are really very much plentiful. It almost has a blind faith in the power of the law to respond to this global environmental problem. So we see, for instance, that the declaration says that the Paris Agreement is humanity's best chance to avoid dangerous climate change. It is actually focusing on what it understands the problem to be, and that's an implementation deficit. So it's not criticizing the design and the structure of international governance, but it's saying that we need to focus more on implementation. So it's quite interesting to see that the vocabulary of enforcement appears continuously throughout the declaration, and it's raising important questions about what is the problem with international environmental law. Is the problem that we don't have monitoring that would be severe enough? As the People's Declaration is calling for severe monitoring and threats of sanctions. Is the problem really that we need to be more firm towards polluting entities? So I think it is interesting to see how this declaration relates to international environmental law, and how the Global Assembly was designed as a response to what was considered to be inadequate international environmental lawmaking. So what we see here, and I'm going to conclude on that, the Global Assembly is quite interesting to think about whether it can lead to more transformative change and the redesign of international climate lawmaking. But at the same time, we see that significant questions still remain about this new mechanism, as it is indeed raising questions about how it can directly influence the COPs, and how citizens need to get a better understanding of how international legal structures work. Thank you very much.
Thank you very much, Dr. Duvic-Paoli. And this is another 2 for 2, perfectly on 15 minutes. So thank you so much. And I just forgot to mention to all the people in the audience that, I mean, we're starting to see questions come in. If you do want it directed at a particular panelist, also you can feel free to mention that, or if you want it asked to all the panelists, that's also not a problem at all. And the speakers can monitor the Q&A as it comes in, and I'll also go through that when the time comes. Okay, so we'll go next to our third presentation, and let me just clean up my desktop. Okay, so we're going to have Dr. Abhishek Trivedi speaking next, and Dr. Trivedi is an assistant professor of law at the Institute of Legal Studies and Research and deputy director of the Center for International Politics and Law at GLA University, Mathura, India. He holds an LLM in international law and a PhD in international climate change law from South Asian University in New Delhi. So I'll give the floor to you, Dr. Trivedi.
Thank you so much, Dr. Choudhury, for giving me this forum. I hope I'm audible to all, and you can also see the screen which I am sharing here. Is it fine?
Yes. And
Yep, it's perfect.
Okay, thank you. So here you can see the title of my paper presentation, that is the global governance of RED Plus and the challenges of applying the international law of free, prior, informed consent. And in this paper, actually, I'm going to argue, or broadly, I have just conceptualized the big one hypothesis, that how the application of multiple standards of international law on the free, prior, informed consent, the standards which are adopted by the United Nations RED Plus program and the World Bank, how these different standards poses specific normative challenges for the states when the states will have to state will have to implement the RED Plus activities, and at the same time will have to protect the rights of indigenous peoples who are living in forest or somehow who are engaged in RED Plus activities by way of their effective participation. So therefore, I'm going to just highlight that how whether we need to adopt a uniform or a coherent approach toward the protection of indigenous people, and the approach which is based upon the human rights understanding or the human rights framework. So this is the broad hypothesis which is a part of my presentation. So moving in that direction, I would like to just highlight the history part of the RED Plus and how it has become a part of the United Nations climate change regime. Initially, basically, it became the part of the United Nations climate change regime through the Cancun Agreement. As far as the United Nations Framework Convention on Climate Change in 1992 and the Kyoto Protocol 1997 are concerned, these two legal instruments do not conceptualize the idea of RED Plus. However, they refer certain provisions in preamble part regarding the some element of forest like deforestation, afforestation, and reforestation, but they did not talk about the full-fledged understanding of the RED Plus, including the conservation part of the RED Plus and sustainable management part of the RED Plus. But anyways, now we do have the Paris Agreement, which ultimately under Article 5 refers to the RED Plus mechanism by way of recourse to the one of the COP decisions, that is the Cancun Agreement. So now we do have the RED Plus mechanism, but it is also subject to the future negotiation as far as the certain other operational modalities of RED Plus are concerned. So now we have adopted RED Plus mechanism. So the question arises that when state will have to implement these RED Plus activities, which are the 5 RED Plus activities, there is a risk that the implementation of these RED Plus activities may come into conflict with the rights of indigenous people who are living in forest. For instances, for example, if one RED Plus activity is going to be implemented in one particular area, and if that area has been kept reserved under the domestic legal system of the RED Plus country, and because of that, by doing that, by keeping that area reserved one, there is a chances that indigenous people might have been shifted from that location to another location. So in this way, the Red Plus activities may hamper their right to land and property which these indigenous people have traditionally occupied. There could also be another situation where the Red Plus activities can hamper the rights of indigenous people. For example, if the Red Plus activities are going to be implemented in an area which is traditionally occupied by the indigenous people, and the government has not ensured the proper participation, effective participation of the indigenous people in the process of the implementation and the planning of the Red Plus activities. So therefore, there become a argument that the state must ensure the participation of indigenous people before they undertake any Red Plus activity. Or not only participation, but the states should also also consult with these people and seek and secure their free, prior, and informed consent before undertaking any Red Plus activity. This is the broad understanding of Red Plus activities and its interface with the principle of free, prior, and informed consent. As far as this, as I have also highlighted a few certain elements of this slide, that indigenous people is also a recognized category under the United Nations climate change regime. This United Nations climate change regime, particularly Cancun Agreement, it also recognized it recognized that when a state will have to implement that plus activity, they will ensure the respect for the rights of indigenous people, and they will also consider the quote unquote relevant international obligations, and will also ensure the full and effective participation of the indigenous people and other forest communities. So two terminology becomes very important. One is that the full and effective participation of indigenous people. The full and effective, this term full and effective is not defined under Cancun Agreement. And the second term is that it refers that when a state will have to implement that plus activity, they will respect the quote unquote the rights of indigenous people while considering the other relevant obligation in international law. Now, what constitutes this other relevant obligation in international law? It actually provides a scope for the Red Plus state to actually incorporate other relevant rules of international law by way of interpretation or possibly by recoursing to Article 31 of the Vienna Convention of Law Treaty 1969, and therefore by way of that interpretation, I have argued that the Cancun agreements, by using the term like other relevant obligation of international law, has provided a platform or had provided a hooks for the incorporation and integration of the rules of general international law, especially the rules of international human rights law, as far as these rules are related to the legal principles of participation, consultation, and free, fair information are concerned. So therefore, the Cancun agreements provide that hook where we can integrate the other rules of international human rights law, which will either justify or prove or disprove my hypothesis that whether the human rights based understanding is adequate to protect the rights of indigenous people when it comes to the implementation of Red Plus activities. But before coming to the human rights based understanding, let me just highlight the transnational governance of Red Plus, because until now, if you have, I have highlighted the governance of Red Plus mechanism under the United Nations climate change regime, which is driven by states. But here in the third point, I am trying to highlight that how the Red Plus governance is also in parallel governed by the non by the international organization, specifically the UN Red Program, which is established by the Food and Agriculture Organization and the United Nations Development Program and United Nations Environmental Program. So these three organizations created the UNRED program. And as far as World Bank is concerned, it has adopted its World Bank Forest Carbon partnership policy, where the World Bank also ensure that states who are being funded by the World Bank will ensure with this World Bank operational policy. So But after analyzing these guidelines, you can see the guidelines here, 2012 guidelines adopted by the UN Red program as well as the World Bank, and the further guidelines regarding on the free, prior, informed consent, then the World Bank operational policies, these two policies which actually mandates the states who are being funded by the World Bank that they will have to comply with these World Bank operational policies and procedural rules. In my analysis, I found that the standards on FP, that these UN Red Program and World Bank apply different standards of FPIC. For example, the standard is the UN Red Program follows is broadly based upon the human rights understanding of FPIC, because the UN Red Program has given a wide definition of FPIC, and most of its normative understanding of FPIC is grounded in the international human rights jurisprudence on the right to consultation, participation, and FPIC, which are ultimately take their legal authority from the right of indigenous people to self-determination, right of indigenous people to land, territory, and other resources. So UN Red Program broadly follows the human rights understanding, whereas the World Bank follows the risk-based approach, which is based on the consultation model. Moreover, UN Red Program follows the right-based approach to FPIC, where it says that free, prior, and informed consent is the right of indigenous people, whereas the World Bank is of the opinion that it is not the right. FPIC is basically a process. So World Bank uses the term that it is the process of free, prior, and informed consultation rather than the right of free, prior, and informed consent. And when it comes to the understanding the legality or the normative understanding of the FPIC, especially the difference between the word consultation and consent, there is a huge difference. So consent actually provides a right where the indigenous people can either give a consent or even withhold the consent, and consultation is a subset of broader consent. So consent actually entails a broader right to the indigenous people. UN program also define and elaborate these contours of FPIC in detail. Right. For example, the UN program has given a wider meaning to the word free, free from influence and undue influence, coercion, etc. Prior means it should be taken before the Red Plus activities are undertaken, or even when the states actually think about that they will in future carry out the Red Plus activity. So from the first stage itself, from the planning, even before the planning of Red Plus activity stage, are required to inform the indigenous people as far as the UN Red Program guidelines are concerned. So the broader understanding of FPIC is provided under UNFC, understanding which is grounded in international human rights law. And then yeah, so these guidelines also help the state to actually to know then at what level they are required to take the consent of the indigenous people, and from whom they need to take the consent of indigenous people, and finally how they will consider the opinions or the differences of opinion provided by the indigenous people, and more specifically that who will decide the entire modus operandi framework regarding this, that how the FPIC will be taken. So broadly, all these things are answered by the UN-led program in detail, and wherever the UN-led program fails to actually provide details on these questions, it basically refers to the international human rights jurisprudence, and there becomes the international human rights jurisprudence relevant. So in this fourth part, I am highlighted that why the state should follow the human right based understanding or human right based framework in order to implement the principle of FPIC when they will have to implement or execute their Red Plus program within their domestic legal system. So I have broadly studied the international human rights law, ICCPR, ICESCR, then other regional convention like and the judgments of other regional convention like European convention, not European, like the Inter-American Codes of Human Rights, Inter-American Commission on Human Rights, and the Human Rights Committees, and the ILO Convention, or two ILO Convention 1957 and ILO Convention 196, and the most importantly, the United Nations Declaration on the Rights of Indigenous People. So after studying all these, the literature, the primary literature relevant to the indigenous people and the protection of indigenous people with the application of their right to participation, consultation, and FPIC. After studying this consultation, I have found certain findings, and these findings is that now the international law has come to the point when it has recognized the indigenous people as subject of international law. So historically, the international law was resistant to recognize the IPs as subject of international law because during the decolonization phase, the international law treated indigenous people as the object of international law. So this is a big trend, big progressive development in international law when it has recognized indigenous people as a separate category where the indigenous people can decide their rights in a community as well as in an individual capacity. International law or international human rights law also recognize the various substantive and procedural human rights as far as substantive human rights is concerned, like the right to self-determination, right to land property and natural resources, right to enjoy their cultural practices, traditional practices, and as far as procedure right is concerned, these rights are the right to consultation, participation, and free, prior, informed consent. So basically, the procedural right of free, prior, informed consent is very well recognized under international human rights law. Though it is recognized in a very general context, but it could be contextualized in the relation to the RED Plus also. So there, however, the international law, though international law further recognize the rights of indigenous people, but the understanding of the FPICs considerably differ from the one legal instrument to another. For example, as far as the ILO Convention 169 1989 is concerned, it focuses much on the consultation dimension of the FPIC principle, whereas the United Nations Declaration on Right of Indigenous Peoples 2007, it broadly follows the consent-based model of FPIC. And as I said earlier, also the UN RED program follows the UNDRIP model of consent-based model. And so therefore, wherever the legal instrument or the different transnational entities follow the consent-based model, it actually strengthens the positions of indigenous people and provides the relatively more protection to them under international law and consequently under domestic law if the state is party to that international treaty. Similarly, if you see the ICCPR and Inter-American Court Convention on Human Rights and consequently the decisions adopted by the Inter-American Courts on Human Rights, they protect the right of indigenous people to participation, consultation, and FPIC based on the communal property framework, which is a very narrower protection provided to the indigenous people because the property is basically a subject matter that primarily falls within the domain of state. So state can change the property law, land-related law, and consequently the rights of indigenous people could be affected adversely. But if you see on the other hand, the ICESCR and ICERD, the International Covenant on against the all form of racial discrimination, and International Covenant on Economic, Social, and Cultural Rights, and Inter-American Convention on Commission on Human Rights, they provide the same protection widely because their legal reasoning or their protection is grounded in the interpretation of the several provisions of the respective treaties, where the treaty recognizes the rights of indigenous people based upon their cultural practices or and a particular way of life, which is basically directly linked to the indigenous people right to self-determination. So if the right is the protection of the rights of indigenous people is grounded in right to self-determination and cultural practices, then it provides relatively stronger protection to the indigenous people. Yeah, I'm going to now wrap it up. So this is the
Dr.
final
Trivedi,
concluding.
Yeah, if you could wrap it up in like a line, because we'll also come back to your presentation and the others at the end as well in the discussion.
Yeah, sure. So finally, the conclusion is that United Nations climate change regime does not provide the adequate the protection to the rights of indigenous people, because it does not prescribe any standards of free, fair, and informed consent, but it leaves the scope for the integration of the the standard of FPIC from international human rights jurisprudence. And if you see the submission of the RED plus country, they have broadly highlighted their adherence to the concept of recognition and respect to the principle of free, fair, informed consent and participation. But how much these countries have implemented this principle in their domestic legal system is yet to see, because the country are at this initial stage of the implementation of RED Plus program, and consequently protecting the rights of indigenous people to participation, consultation, and FPIC. So with this note, I end my presentation here. Thank you so much.
And thank you so much. This is an incredibly enriching presentation, and we'll have opportunity to continue this discussion. And the questions I can see are coming in, so I look forward to going over those as well. We'll go to our next presentation, and it's, I believe, a joint presentation. It's going to be by Dr. David Hughes and Dr. Yahli Shereshevsky. I hope that's, I haven't butchered it too much. And so as a brief introduction, Dr. Hughes is an assistant professor at the Canadian Forces College and instructor at Trinity College, University of Toronto. And prior to that, he was the Trivedi postdoctoral fellow at the University of Ottawa and holds a Ph.D. from Osgoode Hall School of Law. And Dr. Shereshevsky is senior lecturer or associate professor at the University of Haifa, Faculty of Law, and was previously a postdoc fellow at the Fetterman Center, the Fetterman Cybersecurity Center, and a Grotius Research Scholar at the University of Michigan Law School. So I give the floor to both of you.
Thank you. I'm just going to share some slides quickly. Where'd they go? Sorry, just here we go. Okay, thank you, Dr. Choudhury, for the introduction, and many thanks to the organizers for having us here to present our paper titled State Academic Lawmaking. The article describes various forms of direct and indirect cooperation between states and legal scholars, the collective output of which is intended to advance lawmaking objectives. I'll begin our presentation by describing and defining this notion of state academic lawmaking in further detail, and then I'll situate our paper within ongoing discussions about the role of informal lawmaking within the international sphere. Yahli will then lay out the case studies that are at the core of this piece and that evidence examples of the state academic lawmaking process. He'll then conclude by offering some analysis about what this all means, how it affects the way that international law is formed, and what it tells us about the relationship between state and non-state actors. It goes without saying that we're very excited to speak with you about this paper. So to begin, as we note in the paper, our attempt to understand the cooperative process between states and legal academics goes beyond what is perhaps its most obvious association, that is the ICJ's statute referenced in Article 38, to the teachings of the most highly qualified publicists as a subsidiary source of international law. State academic lawmaking, as we define it, refers to an observable generative method by which purportedly independent academic work that was created by scholars with close ties to the state is advanced to support and then entrench a preferred legal position. Unlike the role that scholarship and scholarly opinions may assume under Article 38, state academic lawmaking features work that results from some level of coordination or cooperation between the state that benefits and the scholar that produces the work. It is academic in that it is presented as a scholarly article, authored by an esteemed legal expert or experts, and is published in a leading legal journal. And it is informal lawmaking in that it attempts to circumvent impediments to formal methods of interstate cooperation and consensus building to impart a legal meaning that is not reliant upon the creation of a traditional source of law, like a treaty provision or the identification of customary international law. Simon Chesterman recently wrote that international law academics have always been participants rather than mere observers in our field. State academic lawmaking amounts to an example of this. But in explaining the concept and how it affects lawmaking processes, it is necessary to differentiate state academic lawmaking from the more common ways that international law academics serve as participants in our field. When the international law academic works as a participant rather than an observer, it is often clear what role the academic is assuming. If, for example, the scholar has been commissioned by a state to offer an expert opinion on a legal question of mutual interest, the nature of the collaboration is disclosed. State academic lawmaking blurs the distinction between the role of the scholar and the role of the sovereign, yet it is reliant on the capacity of both actors to advance the lawmaking agenda. In contrast to formal sources of international law that are primarily created by states, states and non-state actors assume an important role in informal lawmaking processes. This is because both actors bring different characteristics and capacities to the informal lawmaking process. The academic contribution offers impartiality and esteem, but lacks a formal lawmaking capacity. The state possesses a formal lawmaking capacity, but lacks impartiality. This brings us to the crux of the state academic lawmaking process. We suggest in the paper that state academic lawmaking introduces a new form of legitimacy into informal lawmaking processes. This stems from the ability of the state contribution and the academic contribution to supplement the other. The state draws upon the impartiality and esteem that is associated with the academic contribution to enhance the persuasive pull of the lawmaking assertion. The examples of state academic lawmaking that we identify and that Yahli will soon present each exhibit to a greater or lesser extent the following features, which collectively evidence the state academic lawmaking process. The first is an ex post lawmaking or interpretative character. Examples of state academic lawmaking advance a particular legal claim or legal meaning. They are not simply claims of legal compliance. Instead, the most common examples of state academic lawmaking occur through either an interpretative assertion or through the identification of custom. Second, they demonstrate prestige, form, and independence explicitly. Having established its lawmaking character, the state academic lawmaking contention continues by emphasizing its academic characteristics. These are demonstrated by establishing the professional esteem and expertise of the authors who will likely be leading figures in their relevant areas of international law. The lawmaking output assumes an academic form. That means it is presented as likely a traditional article, published in a leading legal journal. It will contain footnotes and other signifiers of academic rigor, and it has passed through the journal's regular review process. Finally, the independence that is assumed of scholarly work is emphasized in the work itself, which preemptively denounces any suggestion of state influence. Third, it demonstrates a nexus between the author and the state. Notwithstanding assertions of independence, the state academic lawmaking process features some degree of cooperation between the academic and the state. While this can assume various forms, the level of coordination between the state and the scholar suggests a blurring of scholarly independence, state interest, and lawmaking. Fourth and finally, it demonstrates a capacity to spread norms through repetition and lawmaking diplomacy. The state academic lawmaking process culminates when the academic contention begins to feature within the state's lawmaking diplomacy. As states seek to forward their lawmaking contentions, the state academic lawmaking output is advanced to evidence or independently verify the state's lawmaking claim as part of broader efforts to claim legitimacy and persuade relevant interpretative communities. To be clear, it is our assertion that through these exchanges, examples of state academic lawmaking that possess the described features, these amount to instances of informal international lawmaking. It follows that our paper, within debates about informal lawmaking, which we understand as methods to determine or establish international legal meaning, through progressions that occur in forums other than international organizations, that involve parties that are not traditional diplomatic actors, and that produce outputs that do not result in a treaty or a traditional source of international law. As avenues to advance formal lawmaking initiatives are increasingly foreclosed, either through international obstructionism or when states determine that contracting costs are too high, informal methods are increasingly employed to advance governance and regulatory agendas by like-minded states that seek to find alternative, more efficient means of cooperation. This article departs from this narrative to instead explore the use of informal lawmaking in areas of intense legal contestation. We explore informal lawmaking efforts regarding the use of force, international humanitarian law, and in relation to the law of the sea. In these areas, competition is high, and lawmaking efforts amount to persuasive contests. The case studies that Yahli will now present feature moments in which states seek to gain a persuasive advantage by advancing purportedly independent academic work that was produced following significant state contributions.
So, hi everyone, and thanks again for inviting us to this great conference. And building upon the 4 features of state academic lawmaking that David just identified, I'll provide a brief summary of the 3 case studies that we use in the paper to document the state academic lawmaking process. These examples occur within different areas of international law, as David said, the use of force, international humanitarian law, and the law of the sea, and they are undertaken by various states and scholars. So let me start with the use of force and Daniel Bethlehem's seminal piece in AG regarding the extraterritorial use of force by states against non-state actors, known as the Bethlehem Principles. The paper was published in 2013 within the context of a continuous debate regarding the use of force by powerful states against non-state armed groups in the territory of other states. The law on the issue is rather vague, and many suggested that such uses of force violate Article 2.4 of the UN Charter. This is where Bethlehem article enters the picture. Let me demonstrate the presence of the 4 features of state academic lawmaking in the Bethlehem Principles. The first, the lawmaking character of the principles, is rather clear. They try to shape contemporary norms on the use of force against non-state actors. They push towards a more permissive law in relation to the use of force of states on another state's territory against organized armed groups. As to the second feature, the prestige, academic nature, and independence, it was published in the leading international law journal, the American Journal of International Law, and we demonstrate how Bethlehem himself emphasized in the introduction the independent nature of the work. As to the third feature, the nexus between the author and the state, Bethlehem himself acknowledges the meetings with state officials as well as its own experience that preceded the publication of the paper. And finally, the last feature of lawmaking diplomacy is apparent through the heavy use of the principles by states in their informal lawmaking initiatives. So the US, the UK, and Australia all explicitly relied on the principles in their efforts to push towards their positions on use of law. Our second case study is Mike Schmidt and John Merriam's paper in the Pennsylvania Journal of International Law on the 2014 Gaza conflict. The 2014 Gaza conflict was then the last of a series of recurring conflicts between Israel and Hamas that feature a continuous debate about the regulation of key aspects of asymmetric warfare. Accompanying legal exchanges became persuasive contexts, trying to shape the interpretation of contemporary IHL. This is the context of the Schmidt and Merriam paper. And let me briefly describe its state academic lawmaking features. First, the ex post lawmaking character of the paper is derived from its attempt to promote specific interpretation of controversial IHL positions that is once again, like the Bethlehem Principles, in line with permissive positions of specific states. As to the second feature, its prestige, academic nature, and independence, it was published in an important international law journal. Its authors emphasize in the introduction there, and I quote, extensive academic and operational experience vis-a-vis targeting, and in addition explicitly stress the independent nature of the work. The third feature regarding the nexus to the state is rather clear. The work has significant ties to Israel, mostly through the, and I quote again, unprecedented access that the authors received to Israeli military lawyers. And finally, as to the last feature of lawmaking diplomacy, following the 2014 conflict, there was a parallel exchange occurring about the legality of various IHL issues, mostly through a series of reports by the Human Rights Council, fact-finding mission in Israel. Schmidt and Merriam paper was published soon before the publication of these reports and should therefore be understood as supplementing Israel's report. It provides detailed legal reasoning and justification of the brief descriptions and legal contentions that Israel advanced within its own report. Our third and final example is the Chinese Society of International Law paper, the South China Sea Arbitration Awards, a critical study published in the Chinese Journal of International Law regarding the South China Sea arbitration. Tensions regarding the South China Sea prompt the Philippines to initiate arbitration proceedings under the United Nations Convention on the Law of the Sea. China did not participate in the proceedings that resulted in decisions on jurisdiction and on the merits in favor of the Philippines. This is the context of the critical study. Moving to its state academic lawmaking features, the first features of ex post lawmaking involves interpretations of the law of the sea that promotes the Chinese positions regarding the South China Sea. Most notably, the paper promotes a position according to which outlying archipelago generates substantial maritime zones, even if not part of a state comprised entirely of islands. As to the second feature, prestige, academic nature, and independence, it was published in a well-respected international law journal and was subject to regular peer review processes. The critical study emphasizes the expertise of its author, stating that, and I'm quoting, more than 60 experts in the field of law, international relations, history, geography, and so on participated in this project. The Society also invited more than 20 experts of recognized competence from China, including Taiwan, Hong Kong, and Macau, as well as other countries, to provide guidance and review drafts of specific questions. And the editor-in-chief of the journal, in an editorial, emphasized the independent and academic nature of the critical study. As to the third feature of nexus to the state, several authors pointed to significant ties between China and the critical study. And finally, as to the lawmaking diplomacy, the study has actively promoted by China as part of its lawmaking initiatives in relation to South China Sea. Thus, for example, it was simultaneously published by the Foreign Languages Press of China, and major Chinese state-controlled news agencies reported favorably on the critical study. The last part of our paper looks more broadly on what state academic lawmaking tells us about informal lawmaking and international law generally. It's divided into three subsections that address the move to horizontal lawmaking, power, and comparative observation on informal lawmaking. I will briefly, or very briefly, touch upon several themes that we discuss in this relation. In the first subsection, we observe that state academic lawmaking demonstrates that in informal lawmaking settings, states cannot rely on their own informal authority alone and must engage in a horizontal battle over persuasion that includes various international actors. This complicates the traditional understanding of cooperation between state and non-state actors that focused on coalitions between medium power states or weak states and NGOs to promote international regulation in opposition to powerful states' interests. Here we see that even powerful states rely on non-state actors to increase the legitimacy of their lawmaking initiatives. It demonstrates that even powerful states are willing to play the informal lawmaking game rather than rely on their power to act completely outside the realm of law or legal argumentation. This brings us to our second observation, according to which power in the informal lawmaking arena should be understood as the ability to invest significant resources in lawmaking initiatives. While this ability often correlates with traditional notions of power, and indeed all of our examples involve such states, it's not necessarily the case, and there are some indications that other states begin to take significant part in informal lawmaking initiatives. And finally, we address the notions of comparative and authoritarian international law, and suggest that despite some differences between the critical study and the other case studies, that were treated by some as an opportunity to highlight the critical study as an academic outlier, the common features between the three are much more important, and we see the use of state academic lawmaking across the so-called divide between democratic and authoritarian international law. We suggest that the critical study demonstrates that even states that push towards the return of Westphalian international law order use non-traditional lawmaking techniques when it serves their agendas. So thanks again, and we're very much looking forward to hear your comments and questions.
Perfect. Thank you so much for the very enriching presentation. And we'll go to our last speaker and last presentation. And that's Ms. Agnieszka Szpak. And Dr. Szpak is Associate Professor of at the Faculty of Political Science and Security Studies of the Nicolaus Copernicus University of Mathura in Poland, and she's author of more than 150 scientific publications, so very well published, particularly in the areas of public international law and international humanitarian law. So I'll give the floor to you.
Dr. Choudhury, thank you for your introduction. Okay, so thank you for this opportunity for having me here. And the subject of my presentation, as you can see, is global governance, international law, and cities. And by way of introduction, the role of global cities in global governance is growing stronger. The particular connections between global governance and progressively globalizing cities, combined with the growing significance of cities in general, has made them powerful actors in the international arena, and therefore it necessitates a new research approach. Cities actually have so far have been underrepresented in the literature in international law, including textbooks, and with the growing role of cities also in creating and implementing international law, the scope of their activities and decision-making in the areas of international law and international relations is also growing or expanding. And in this context, by global governance, I mean group efforts aimed at identifying, comprehending, and solving global problems that exceed the capacities of individual states. As there is no actual world government, this model provides government-style services at this level, encompassing a rich variety of cooperative arrangements for problem solving. And cities are part of such processes. The future of humankind actually increasingly depends on what happens in cities. This message is a sign of the recognition of the growing role played by cities in dealing with global issues. Among the main reasons for this are the fact of cities' increasing participation in global governance and of international city networks being forums for discussing common problems, as well as finding and sharing solutions, and becoming a new space for global governance, I would say global multi-level governance. So my aim in this paper, this presentation, is to show the forms of cities' participation in international affairs and processes of global governance, consequences of such participation for international law, and the reasons cities increasingly use international law vocabulary. So as to forms of cities' participation in processes of global governance, it takes different forms. It can involve engagement in intercity diplomacy and the development of external relations with a view to promoting political stability, security, cultural exchange. Cities also form networks, the most important of which include United Cities and Local Governments, UCLJ, C40 cities or Eurocities. The objectives of such networks range from educational research, cultural exchange to humanitarian relief and migrant refugees integration. This is actually, the city networks is not a new phenomenon, but what is new is the fact that currently a number of international city networks allocate more resources to lobbying and so-called city diplomacy at the global level. Similarly, many of the active networks go beyond information exchange and joint projects, seeking new ways to participate as actors in global policy-making processes. The scope of issues addressed by city networks has actually reached unprecedented proportions. City networks are the most important and vibrant form of cities' participation in global governance processes. And city networks cooperate not only because of the problems they have in common, but also, which has to be stressed, because they have solutions that can serve common well-being, regardless of partisan values or political cultures. City networks offer practical ways for citizens to mobilize the resources to become involved in global advocacy and share innovative technologies and practices employed to remodel local policies. Such global networks of cities strengthen their influence, and this marks a break from the competitive order of nation states as localities from all over the world manage to cooperate. Partnerships between public international organizations and cities or city networks have become a regular occurrence. The list of UCLJ's partners alone is endless, including, for example, the European Commission, the World Bank, the International Monetary Fund, UNESCO, the International Labour Organization, or the UN Development Programme. These are just examples. These alliances not only facilitate city networks' pursuit of their global and local agendas, but also offer them access to the world of international policymaking and provide them with a platform that is more formal than that of unaffiliated city or city networks, operating on their own. Establishing connections to international organizations, particularly those that are active participants in debates on international policy, can offer city or city networks opportunities to influence such debates directly or indirectly. Cities' participation in international relations may mean also the implementation of international treaties on their own initiative, even without the consent of their governments, which challenges the traditional notions regarding internalization and domestic implementation of international law. For example, an example of cities implementing a treaty without their state consent was the 2005 plea directed at other cities by the mayor of Seattle, Greg Nichols, who urged them to implement the Kyoto Protocol through their local laws, envisaging reduction of the GHG emissions. After the positive answer, a network of over 1,000 cities was created. It was called US Mayor's Climate Protection Agreement. And as you all probably know, the US did not ratify the Kyoto Protocol. In the same vein, in response to President Trump's infamous justification that the US, for the US withdrawal from the Paris Climate Agreement, that he was elected to represent the citizens of Pittsburgh, not Paris, the mayor of Pittsburgh, Bill Pezzuto, promised that Pittsburgh will adhere to the Paris Agreement, as this is the best course for the future of the city's economy and its inhabitants. These are just examples. All of this leads to the conclusion that cities are participating in creation of international law and or its enforcement. Research on the normative activities of contemporary cities offers evidence that the meaning of international law is no longer limited to the rights and obligations of coexisting states, and that there is a variety of theoretical approaches to conceptions of global, international, or transnational order. The era of classic international law is drawing to a close and will probably give way to a hybrid system in which the traditional actors, institutions, and processes will mix and merge with a variety of transnational ones. So what are the consequences of such processes for international law? Taking all this into account, and also as, for example, Professor Swiney argues, we need today a new vocabulary instead of international law, or even an entirely new conceptualization of the changing role cities play in international politics. The terminology and framework used at present are poorly equipped to grasp accurately the growing national and international influence of cities and their changing status. And in the literature, you may find a few propositions of the new terminology that may accommodate the growing role of cities in international relations and global governance. So the first one is international local government law. This is a term coined by Gerald Rook and David Barron in their article in 2006. Their aim was to highlight the novelty and comprehensiveness of emerging international legal rules and regulations for cities. And one of their particular aims was to introduce the issues of international legal government law into the sphere of international law, although international law traditionally has been a tool to regulate relations of sovereign states. International local government law was supposed to be a response to the promise and the peril of permitting cities to exercise power. Contrary to traditional conception of international law, international local government law focuses not on states, but on local governments and on cities in particular. It aims to empower them and accommodate their increasing influence in international relations and international legal processes. And this actually coincides well with the phenomena such as cities internalizing and enforcing international law, as well as using the vocabulary of international law. Within the legal framework of international local government law, relationships between states and their cities becomes an appropriate subject of regulation. The second term is international urban law, coined by Louis Eslava and George Hill. They argue that since the city has researched as a locus of international discourse, this has established a dynamic interaction between international and local development policies and urban laws, which they identify as international urban law. They explain that the emergence of modern international law based on national sovereignty has eclipsed to a large extent the city's position in the global order. Although the nation state has, in their opinion, has not been displaced yet, cities have thus reappeared as governance spaces that are ideal locations to realize developmental aspirations, now embodied in the discourse of urban security, environmental and financial sustainability, and human rights. The response of city administration to this trend was more visible participation in the national, international, and transnational processes of decision-making, which led to increased formal recognition of cities by international institutions. Such processes include the already discussed global city networks that enable cities to exercise their influence and cooperate without tensions characteristic for states cooperation. They also encompass cities' participation in informal international lawmaking and its enforcement. The third term is transnational legal process, coined by Harold Hongu Koch. This idea envisages a role not only for states, but also for other public and private international, or we can say transnational actors, including cities, states, but also, the key idea underlying transnational legal process is based on the notion that international law is no longer reserved for nation states. According to Koch, all of those different actors make and remake transnational law, which is the hybrid law that combines domestic and international, public and private. And by that, they do that by generating interactions that lead to interpretations of international law and that become internalized into domestic law and binding as domestic law. This placement of transnational law between public and private, as well as domestic and international levels, coincides well with the nature of the already discussed city networks, which can be described as multi-actor, multi-level partnerships where cities are active participants. Such partnerships transcend this divide between the public and the private and challenge the traditional strictures of domestic versus international. As mentioned, cities enter into alliances with international public and also private institutions. They internalize and enforce international law, crossing the line dividing public and private, formal and informal. As a result, they also acquire a characteristic feature of transnational law, it is legal pluralism. And finally, we have the global law proposed by Christy Swiney. She defines global law as primarily composed of voluntary self-enforced commitments that are drafted, implemented, and enforced by global non-state actors, including cities, but that are arguably no less real law than much of what qualifies as state-made international law. Professor Swiney explains that the term international cannot be used appropriately any longer to denote a sphere where states have been joined by a variety of other actors. Global law is supposed to mirror the increasing role of cities in dealing with global problems such as climate change, migration crisis, or pandemics of infectious diseases. While state actions, including those based on international regulations, do not suffice, cities may turn out to be more efficient with dealing with such challenges, not only at the national but also international level. And this in turn calls for a new concept of international law, a new concept reflecting cities' position. Cities that form global networks that implement and enforce international law independently of their states, that are engaged in their own international relations, that are autonomous and separate from their counterparts at national level. This can be achieved, for example, when cities mimic their national governments in terms of structures and actions by establishing their own international affairs offices, or by adopting legal regulations similar to those of states, like the European Charter for Safeguarding Human Rights in the City. All these four propositions of new terminology deserve attention as they attempt to accommodate the increasingly influential position of cities and their networks in international relations. So the consequences of cities' increasing participation in global governance may be a need to adopt new vocabulary reflecting the expanding scope of international law. And very briefly, what are the reasons for cities to use international law vocabulary? There are actually two reasons. On the international level, by citing international law, cities may attempt to establish an independent platform that will allow them to have a say in international politics, which is still state-dominated. On the national level, cities employ international law language to contest the actions or lack of actions of their state governments. In both cases, cities try to act independently of their nation states, pursuing their own policies and goals, even when these are not compliant with the national ones. Evidently, as cities are gaining in importance, the states no longer are seen as the only actors with influence on international lawmaking. And to conclude, from mere objects of international regulations, cities are progressively transforming into subjects and actors in the sphere of global governance, international lawmaking including. As argued by Gerald Crook and David Barron, cities have entered into a new phase in history. Their orientation has become external rather than internal. Their associations have become global rather than domestic. And it is all the more important as it is expected that by 2050, cities will be a home to 66% of the global population. And as visible with regard to cities in many or even most issue areas, hierarchical modes of governance established after World War II have given way to alternative forms of organization focused on network-based architectures. Thank you very much for your attention.
Thank you so much, Dr. Szpak, for this wonderful presentation. So we have a little over 20 minutes remaining. What I'll do, if it's okay, if I have permission of the panel, is that I'll give a couple of comments for all of the papers, just as food for thought, and then we'll turn directly to the questions before I let you respond. And that way we'll hopefully get as much as possible. And I'm also going to time myself so I don't go over. So starting with Rebecca, wonderful presentation, clearly relevant even to my own research in Afghanistan. And I see that in your work, you're presuming that the lack of clarity in international recognition is bad. And I wonder if we can also view it as a strength, because sometimes when we think of rights, international recognition, I'll get to in a second, but when we think of rights, we don't always want to nail them down with too much determinacy so that courts can have flexibility. And so with international recognition, could it be that lack of clarity allows for countries to decide legitimacy without being treated as a pariah? Because I'm reminded of in the 1990s, Iraq invaded Kuwait, and there was a Security Council vote, and Yemen voted against it. And one of the consequences of Yemen being Yemen and Cuba, but Yemen voting against the Security Council resolution is that it ended up having international aid reduced to itself because it was kind of a pariah. So we don't want to get into this situation of everyone having to get on board with the international recognition. Isn't flexibility good in a certain way? Or could we not see it as such? Possibly. Now, in terms of questions of representation, you mentioned that it's not ideal if certain UN agencies one UN agency will recognize one organ of the state and another UN agency will recognize another. And you mentioned, I think you used the terminology, obviously, this is not ideal. But actually, when I read it, I thought the exact opposite, that it's precisely because it's pragmatic and that it allows the job to get done. And so it's not being fixated on overly rigid standards, but rather it allows for a very quick and pragmatic response. So is that a type of balance that we should keep in mind when we're moving forward? Yeah. Next, in terms of the shift that happened in 1990 between effective control to democratic legitimacy, I wonder if it's something that explains why that happened in terms of the General Assembly. The idea of deferring the decision on representation, I wonder if this it can be seen as flaky on the one hand, but I wonder if it's also kind of a strategic tool. How when on contentious issues, sometimes you actually defer on the decision. I mean, Hannah Lerner has talked about this in terms of constitution making, how you want to defer it so that it can be dealt with later on. Many people aren't going to agree with this for obvious reasons, but I just thought it might be some food for thought. So I'll stop there with your presentation but I could go on much longer because it was so wonderful. Dr. Leslie Ann, on your presentation about, I wonder when you say on page 4 how elected leaders don't represent their people, maybe could that be too strong of a claim? And it can be so easily brush aside these elected leaders. And so maybe a more detailed and extended discussion on why you feel elected leaders aren't really doing the representative role. I think there's a lot of truth to what you're saying, but I guess rounding out that discussion. Now, at some point you mentioned in your presentation and paper how the citizens' deliberation helps to bridge ideological differences that elected officials can't. And I wonder if this is quite a strong claim. It would have to, one would think that this needs to be justified, because this notion of deliberation is very interesting. And it seems to assume that there won't be ideological tensions, but you would think that there would be such tensions, because it's not clear that citizens are more deliberative and states are more combative. I think that would have to be argued, or if you don't think so, at least clarify that. And also the mechanism of deliberation. In terms of the process, I just wonder, what is the process through which the Global Assembly operates? Is it a bit ad hoc? And if it is a bit ad hoc, does it affect its legitimacy? Next, I wonder to what extent this wonderful discussion you've had overlaps with the discussion on legal consciousness. And you might be familiar with this literature, how a particular legal discourse kind of reorients the entire way we think about climate change and the role of citizens in the process. I think your discussion on means, this being about means and not ends, is very interesting, and I think it warrants even more discussion. And I guess just a last point. Actually, no, I'll stop there because I'm going quite a bit, but I think it was a wonderful discussion that you provided us food for thought with. Now, in terms of Abhishek and your wonderful presentation, there is ambiguity in free and prior informed consent, and multiple institutions adopting their own definition. Now, if we shift now, by bringing in the human rights-based framework, are we not kind of just shifting that ambiguity? And that there's ambiguity with free and prior informed consent, but now we're going to use the notion of human rights-based framework, but it doesn't that just simply shift the ambiguity? And at that point, there's still going to be room for interpretation and flexibility, something just as food for thought. Now, in terms of, okay, I understood how you mentioned the FPIC is used differently by these different institutions. I wonder why this matters a bit more. I understand you mentioned there's benefit and consistency. Now, I wonder if you can make that more concrete, like how are Indigenous peoples harmed by the current practices? Can you make it concrete? And that will help tease out like what are really the stakes behind having consistency in the FPIC. And I especially found interesting how the ability to, like when we were talking about consent, the ability of Indigenous persons to withhold consent is kind of up in the air. And that's very important because it talks about power differentials. So I wonder if that even warrants a bit more discussion, especially when you're contrasting consent model and the consultation model, because like that contrast could be brought out a bit more. And if under the consent model, Indigenous persons don't have the ability to withhold, then it almost seems like the two models collapsed into one another, because that would almost be an important distinguishing factor. So I'll stop there for your wonderful presentation, but we'll continue with when the questions come up. David and Yahli, I understand how academic lawmaking is persuasive contest, and I think you mentioned that from in your paper. And I wonder what is the boundary between what we treat as informal academic lawmaking versus informal academic like literature as an informal source of law. And so, look, I guess what I'm saying here is that states may be using academic lawmaking to benefit from the perception of neutrality, and that supports the lawmaking process. So is what's happening here lawmaking, or is it legal persuasion? Like, is your paper state academic lawmaking or state academic legal persuasion? The title sounds terrible, so I don't think you should change it. But I mean, just in terms of food for thought, is it lawmaking, or is it that the state academic body is being used for interpretation? And second, is it really less hierarchical, or is there at least some level of hierarchy even in like the academic lawmaking? Because you said it's published in leading law journals. Isn't that just, and this is elite American predominantly academia, isn't this a new form of hierarchy that's arising just in a different way? I did find very interesting the notion of mutual reinforcement. You only mentioned that once, but this notion that there's a co-production of formal methods in academic lawmaking, I found very interesting. You did mention there's a blurring between like scholars and sovereign, though I did question whether there is really a blurring, because it seemed authority still lies with the state. Like the state is deciding when it's using the academic lawmaking in terms of legitimizing its decisions. But that's just something I pose out there. And is academic lawmaking actually as neutral or impartial as one may think? And I think you start to touch on this on parts, and maybe I also glossed over it quickly, but we know that academic writing is very political. There are schools and camps, and I mean, maybe academics themselves present their works much more impartial and neutral than they actually are. So just some food for thought there. And lastly, with Agnieszka's presentation, I wonder if we could tease out even more the tensions between like the domestic obligations and commitments under international law and governance at the city level. You start to do this very well when you're like mentioning Trump and the Paris climate and the city of Pittsburgh, and so really teasing out that relationship between the city and the state. I next wonder if you can draw comparisons with private international law. And so, for example, when businesses are interacting with one another, they're using private international law. And so do we treat cities more like states in the public international law realm, private businesses, or in the private international law, or something in between? And what are, I guess, the stakes of treating them one way or another? Next, I wonder, there's a lot of talk about there being cooperation, but I wonder if it's a bit idealized in the way that cities cooperate. Like it would greatly enrich to pose the opposite question: what problems could arise? Could there be new tensions? And what would state-to-state tensions look like? City-to-city tensions look like? I found the examples that you raised, like Pittsburgh and the Mechelin Declaration, very, very enriching. And I wonder, when you go through the terminologies, if you could also contrast them with one another. Because when you're talking about international local government, international urban law, many times it seemed that they were talking about the same notion. So, to what extent is there overlap between these ideas, or do you see them differently? And lastly, even between cities, there's so much between states, there's so much variation, and between cities, there's so much variation between size, development, etc. So to what extent that factors into the analysis? So that's it for my comments. I won't go any further. Before giving the floor back to you guys, I'll go through, I guess, one question that's been addressed to each of the speakers, and then I'll turn the floor back to you. So first, one question that was posed to Rebecca is, did the UN General Assembly take any action in regard to the legitimacy of Ukraine governments following the Maidan Revolution? Directed at Dr. Leslie Ann, do you think that there's significant problems with the structure of these assemblies themselves, and hence the declaration is insufficient, or is the implementation is truly the area where the work has been done? For Dr. Trivedi, does the absence of an explanation of full and effective participation in Indigenous people cause problems in ensuring actual representation of Indigenous communities? And for Drs. Hughes and Szhereshevsky, whose views are these independent academics bringing in addition to traditional state-centric views expressed by the diplomats? Do you see the potential for these independent academics to bring in voices that are unheard, like minorities, Indigenous persons? And lastly, does the panel generally think of the increasing role of People's Tribunes as an actor in international law? What do you think about this? So I guess we'll go in the order of the presentations. So I'll give the floor to each of the speakers, starting with Rebecca.
Yeah, thanks for that question. I can answer that one fairly quickly. The General Assembly did pass a resolution on Ukraine in 2014. It wasn't on the legitimacy of the Ukrainian government as such. It was on the status of Crimea and the validity of the referendum in Crimea. The General Assembly resolution reaffirmed or declared that the referendum had no validity and that it wasn't effective in altering the status of Crimea, and it called upon states not to recognise the result of the referendum or the altered status or any altered status of Crimea.
Great. I'll give the floor to Leslie Ann.
Thank you. So about the question from the audience on implementation, it's a very good question. Is the problem with international environmental law implementation? And it's what the People's Declaration seems to assume. It's a position that the international community has taken since the 1990s because the international community was realizing that now that we had the tools, the problems were not actually being addressed. So I think there's a big question about, well, if all the tools that we have were properly implemented, would it be enough? And that's still a bit uncertain. But I think the bigger question is also, what do we mean when we talk about implementation? And what we see often in environmental law is that actually we have norms that tend to be very vague and very open, and they leave actually a very wide margin of appreciation. So even if we're saying we need more implementation, it's unclear whether we can actually monitor this implementation because of the flexibility that the field is giving. And about your comments, thank you so much for all the comments that you've given on the paper. I'm just going to maybe say one thing about this very interesting comment about, are citizens more deliberative than states? And of course, it is a very interesting question. There's basically what we have at the moment is the theory of deliberative democracy that tends to say, well, if we put people together, it will work better. And what we've seen in the last couple of years is that now we are testing this idea. So it's still a bit uncertain what the outcome is. We have this theory that if actually people talk to each other and listen to each other and understand the position that everybody is taking, their interest will slightly change and they will be happier to accommodate different interests because they will understand where everybody's coming from. And that's not what we see in international negotiations, where it's basically power politics and people are not actually talking to each other. But that's a very interesting question because we don't necessarily know whether this is going to work. What we have so far is experience at national and local levels, and it seems to be working. Of course, it doesn't mean that everybody agrees on everything, and that's completely normal because in a society we can't agree on everything. But just trying to understand each other's position tends to make it easier to actually adopt common positions that everybody will consider are kind of adequate. Thank you.
Thank you so much. Dr. Trivedi?
Thanks very much for this question. So let me just answer the first question regarding the shifting of ambiguity from the climate change regime to this international human rights regime. Well, it could, you can say that it's shifting, but because law is always ambiguous when it comes to the implementation. So the point is that there are two broad things which we need to understand. First is that the very much legal understanding of the legal nature of the Cancun Agreement and the legal nature of the obligations or the legal nature of FPIC as it is grounded under international human rights law. So there is a huge difference because the entire understanding, normative understanding of the climate change regime, including the particularly the Cancun Agreement, in which this the concept of full and effective participation is mentioned, is not based upon the human rights understanding and the justice concerns. So that structurally is this Cancun Agreement is flawed because it is devoid of incorporating the justice element, justice concern, and the human rights language and the rights of indigenous people, which we can't claim. And in fact, the the legal status of this COP decisions is again as problematic in terms of whether they do have the autonomous legal standing in the international law. So it is not the shifting, and if it is shifting, then still it doesn't matter, because if we take the help from the international human rights law, which is less ambiguous, and if it is ambiguous, then we can interpret that with the constructive ambiguity rather than deceptive vagueness. So there lies the beauty of the international human rights jurisprudence, to give it a proper meaning, legal meaning, the detailed meaning, precise meaning, to the elements of the crime form concern. As far as the second question is concerned, how IPs are affected if the different international organizations or different actors, international organizations like World Bank and UN program apply different standards of FPIC. Let me give you just a practical example, because states are at their nascent stage of applying and implementing the REDD+ activity within their domestic legal system. So I do not have the empirical data, but let me just give you one example that from the India side. Let's see if two REDD+ projects are two different states in India are going to implement two different REDD+ projects in these two respective different states in India, and these two different REDD+ projects are funded by two different international entities. For example, if one is funded by UN REDD program and another is funded by the World Bank, then within the Indian territory, these two REDD+ project funded by two different international organizations will have to implement or comply with two different standards which are mandated or which are provided by these two different organizations, because ultimately these two REDD+ projects are heavily dependent upon the financial assistance provided by these two different organizations like World Bank and UN REDD program. So, for example, World Bank, if provide a financial assistance and technology advancement to these for the implementation of REDD+ activities in India, then India will have to comply with the World Bank safeguards. So therefore, it becomes normatively or theoretically becomes problematic, because then India will have to apply two different standards for the same people living in the territory of India, which and the people who are this citizen of India.
Perfect.
Then the third is that consent.
Before going on, I mean, we could keep on going for a lot, quite a bit longer, because it was an incredibly enriching presentation that you made and that all the speakers made. I do want to give I do want to give some time to the other speakers as well, just to address their comments. So, I mean, at the end, if we have time, we'll get back to you. But thank you so much, Dr. Trivedi, for the comments. It was extremely important and very interesting. I do want to give the floor to Dr. David and Yahli, if that's okay. Unmute.
Yeah, thank you. If we're out of time, we're happy to cede the floor to Dr. Szpak, and we can follow up after, because we have some thoughts on these questions. But I recognize we have about 1 minute left, so we're happy.
We can go over a minute or two, but
okay. In that case, very quickly, I'll start with the last question that you posed, Dr. Choudhury, because it seemed to align quite closely with Slava's question from the chat about impartiality and neutrality. And there's a quick answer to that one, and that's simply, when we talk about impartiality, we're talking about formal impartiality from the state. I completely recognize that academics bring biases in their own work, and these are reflected in their outputs. So no disagreement there. But in each of the case studies, they explicitly cite that they are writing in a formally independent capacity from the state, and that is what the state points to as value, that this is not our self-serving justification, this is an expert justification from an external source.
Yeah, just maybe one point about the question about hierarchy. So again, clearly there are power differences, and we address power all along our piece, but it's not like formal capacity to create international law. So the playground here is more horizontal. It clearly powerful states, even in this informal setting, has more power to influence the law, and specifically in our case to act in what we call state academic lawmaking. And we see that all of our examples involve traditional powerful states. But we do see some signs that there's a possibility for change, and we address in the paper other instances in which medium power and weak states operated in the settings of informal lawmaking in similar ways to make changes to the existing perceptions of international law.
Perfect. Thanks so much. And we'll go to the our last speaker, Dr. Agnieszka, if you have some concluding remarks.
How much time do I have? Because there were so many questions.
A minute or two, if you, but go. We don't want to cut you either. We want to make sure you
I
get
will try to. Okay, so as to the tension between city and the state, I think this is an interesting concept. I gave just examples of Paris Agreement and Kyoto Protocol. This is a concept of cities kind of bypassing states. There are more examples that cities implement international without their state consent, like Los Angeles and San Francisco implementing International Convention for the Elimination of Discrimination of Women, even though the US is not a state party to this. So this is, I think, an interesting concept, or the sanctuary cities, yes, that offer sanctuary to migrants, even though their states are not very or are unwilling to accept migrants. Okay, as to the question of private international law companies, it would be difficult to compare them to businesses because they definitely are more, they have more democratic legitimacy, yes, because they are chosen and the local governments are chosen by citizens, and they are the level of the government closest to the citizens. So I'm not sure. I was thinking maybe they are similar to NGOs also trying to lobby to achieve their aims. But definitely cities are part of their states, yes, although with some specific identity. As to problems and cooperation, the main problems that cities encounter in their cooperation are, as I know also from interviews with some representatives of local governments, is finance, lack of staff sometimes, lack of competent personnel that can, for example, speak, I don't know, foreign languages. So I think these were the main issues. And okay, sometimes this backlash from the state. As to contrast the terms with one another, generally, I would say that those two first terms, international urban law and international local government law, they still rather concentrate or treat cities as objects of legal regulations and do not necessarily recognize their agency. The term global has this advantage that it removes this notion, root nation, yes? So it is more inclusive, at least on the surface. Okay, so that would be the very quick comparison. And you mentioned the variation on different size, for example, of cities. Yes, of course, it affects them. Those most active cities are, of course, global cities, the big cities, but in fact, all the cities are in a way globalizing. They, to a certain extent, show manifestations of globalization. Even smaller cities, I don't know, participate in city networks, or they have twin cities. Of course, with city networks, there is a problem, especially with smaller cities, because they don't have so much money. They have to choose in which they want to participate, because there are fees. It requires time and engagement. So yeah, that would be my answer. Is it okay?
No, that's perfect. I mean, this is all food for thought as well. And hopefully to all of our presenters today, thank you so much for all of your comments, remarks, and we hope that we were able to provide some reflection. And we hope that you also consider keeping in contact with one another, given there's how much overlap there was. And we've gone a few minutes over, but I mean, I'm very glad it was for an incredibly enlightening and enriching panel. And thank you so much for the engaging discussion today, and look forward to you participating in the rest of the conference. So thank you so much.